All right, a very good afternoon, East Africa. I hope you're all doing well and that you're keeping safe wherever you are, whether you are in a humid area or whether you're in a very chilly zone like I am this afternoon. It's an absolute honor to have you all here with us this afternoon. Today we discuss a very pertinent yet very pressing issue. And this is an issue that concerns us, lawyers, who are living and residing in this side part of the world. Increasingly, our profession is facing a wave of hostility like never before. And this session titled "Under Siege: Defending Lawyers, Upholding Justice, and Safeguarding the Rule of Law in East Africa" is targeted at countering this hostility that we continuously face. And today afternoon, we have colleagues, experts on rule of law, but also colleagues who have faced the wrath or the unfortunate incidences that have happened over a couple of months or even years. This vice has been ongoing, and it has really taken our profession aback. This afternoon, we are privileged to have Mr. Robert Okot, my good friend and brother, as our moderator. He'll be taking us through this session. He'll give us a brief background about this session and also introduce our esteemed panelists, and then take us through this very wonderful discussion. Colleagues, remember the session is being streamed live on our YouTube platform, East Africa Law Society, and we are also live on Zoom. So we urge you to share that link with a friend and tell them that the session is on. I'd like to also honor and take cognizance of notable advocates on the platform. I take cognizance of my senior, Mr. Philip Rugaba, the retired Justice Robert Makaramba from Tanzania. Thank you so much for joining this session. Let's keep joining this session. Let's share this link. And right now we'll get started, and I'll hand it over to you, Robert. Robert, you have us for the next 2 hours. Thank you.
Thank you very much, Gabriel. Good morning, good afternoon, everyone, and welcome to today for discussion.
But I think your audio is faulty. Can you please ensure that we can hear you? Thank you.
Am I more audible now?
Yes, you are more audible now.
Okay. Good morning, good afternoon, everyone, and welcome to today's critical discussion. Under Siege: Defending Lawyers, Upholding Justice, and Safeguarding the Rule of Law in East Africa. I am honored to moderate this important conversation because as we gather here today, we recognize the vital role lawyers play in promoting justice, human rights, and the rule of law in our region. However, many face significant risks, threats, and intimidation in their daily work. This event aims to shed light on challenges and explore ways to support and protect lawyers who are often on the front line of defending justice. Our esteemed panelists will share their insights and expertise on the risks that lawyers face, strategies for building support networks, and the importance of upholding the rule of law. I look forward to a thought-provoking discussion that will inspire action and solidarity. Let's begin this important conversation, and I invite our panelists to take stage. First is Mr. Aaron Kiza, an advocate of the High Court in Uganda, a human rights lawyer, an environmentalist, a poet, an award-winning human rights lawyer, but most recently, a graduate of Chitalia prison because he was defending human rights. You're welcome, Mr. Aaron Kiza.
I'll put on the video briefly, and then I wish you could see the words on my T-shirt. I'm saying free message, and anyway, you can't see it very well, but that's the T-shirt I'm putting on, and that is a good context for what we are going to discuss. So it is me you are discussing with. I'm in a car. You have to, if you are living on the front lines, you have actually, you can't afford to be very comfortable. I see Dr. is in Arua, is in, yeah, so that is our life. Us at the front lines, you are always on the move or always in some kind of discomfort. Aaron Chiza is my name, as Robert has very ably described me. I'm a human rights lawyer and many things, including a parent of children. So I'm contributing to the development of the East African community, ensuring that it has the next generation of East Africans. Yes, I'm a very recent graduate. I just don't have a certificate, but I graduated from Chitaria Max Prison on the 4th of April of this year, simply because on the 7th of January, I was violently arrested and tortured as I tried to represent USJ and Rutare in a kangaroo military tribunal at Machinde in Kampala. The reason I was arrested is part of the problem of the risks, the daily risks that the lawyers in practicing in East Africa face, and that was none other than doing my work, representing people, and also what people don't know, part of my problem was also my work on social media and in the media generally, lambasting the military usurpation of the power of the judiciary, civilian judiciary, to dispense justice and trying to grab that power which they didn't have. So I didn't bother getting into definitions of what living on the.
So, Aaron,
Yes.
maybe just to further guide our conversation, who are the people, what kind of lawyers are targeted, and why are they targeted?
Okay. So if you're doing, let me start with those lawyers who are not targeted. If you are only, if you're doing family law, it is unlikely that you are going to be targeted, and that's all you're doing. If you're doing mere transactions, registering mortgages, selling and buying land, you are not targeted. Of course, this question assumes that the targets are the state machinery. Other areas of legal practice can be targeted once impunity has spiraled out of control. Even in family disputes, you can be targeted by the other person because there is loss of erosion of confidence in the judicial system, people wanting to take law in their hands. But for the most part, it is human rights lawyers who are targeted. It's lawyers who are questioning power that are targeted. It is lawyers who also, whose legal work is very impactful, but impactful in the sense that it robs the military or the business guys in the wrong way, or the politicians. Those are the key threats: the politics, the money, and the guns to the lawyer. And most of it would be human rights lawyer or a natural resources lawyer. Another group of endangered species are natural resources lawyers. If they are going to steal a forest like Karura Forest, Mavera Forest, Semlik Forest, and you come in, you are likely to be targeted. If they are going to evict people massively, maybe from a slum in a town or some ranch in a village, some village it's going to be evicted. And for you as a lawyer, you use your office of a lawyer, you use the law and weaponize this to push back against that land grabbing, that forest grab, against that massive eviction. You will be targeted. If you are using the law to defend vulnerable people against very powerful guys, you will be targeted. I hope that part of the question is being answered.
Aaron, I know you've just come out of prison. over Dr. Kizza Besigye's case. Could you please share some more personal experiences other than the Dr. Kizza Besigye case that had led you to Chitaya Max prison?
In 2021, two of my workmates, Odur and some, were arrested because they are working with Nicolas Opio. They were arrested with Nicolas Opio and some other lawyers because they were doing some human rights documentation relating 2021 elections. Just recently, there is a lawyer who is participating in opposition politics called Mudio Were in Iga. He wants to contest somewhere in Iganga. He was kidnapped for almost a week, and then he was lured, and then I represented Isaac in some of his interaction with police. He has had like 3 of them, but the biggest threat to him, I mean the US president, is he's now facing contempt of court charges, and his appeals are not making much progress because there is some judicial bias against him. Mabirizi served 18 months. Mabirizi is a Ugandan lawyer, not an advocate, but a lawyer. He served 18 months in prison. All of them, appeals didn't work for him. There is a lawyer called Sebaduka in Uganda. His case, I think, went up to Supreme Court. For him, I think his issues were with the Chief Justice. So in Uganda, it is daily bread. When the Kenyan IGM lawyer or International Justice Mission was murdered a number of years ago from courtroom. He was coming from courtroom in Kenya and murdered. I went and met IGM Uganda, and we tried to do some of those things. So then in 2020, I sent 7 lawyers in the field. All of them were arrested in Chiryandongo. This was a land matter. We are trying to deal with forced evictions. So there are all sorts of things, but arrests, illegal arrests, abductions, detentions, and more recently sentencing and convictions over what people call contempt or other things are some of the biggest physical risks. And as we have seen in the case of Wire in Kenya, some of them really don't turn back. It can be very fatal. But so the risks are physical, they are legal, they are social. You would want to know about the social, especially the economic risks, socio-economic risks. First of all, some people will not give you work because they think you are an opposition lawyer. Once you do human rights, people say that, this is an opposition lawyer. Or they say that the president may not like you to be seen with this kind of lawyer. So they draw out you may not get as much work as you would have got. Some people will just fear to associate with you, creating both social and economic barriers. There can be targeting on your families. My children, for some, the first month in my detention, we had hidden from them. Eventually, we had to tell them they had to come to Chitaria. And that happens for all families are impacted in different ways by harassing lawyers for being lawyers, for doing their work. Some people lose loved ones. So the children are targeted, the spouses are targeted with the consequence. I know some Ugandan lawyers who have backtracked from this kind of work completely simply because of threats to their families. One of them was a lecturer. They couldn't intimidate him. They went and intimidated his wife, and the wife had to make sure that he would go home by 4 p.m. and whatnot, and he's no longer very active on the front line with us simply because of the military. Once they can't intimidate you, they intimidate the family, and then the family will exert pressure on you and you leave. And then the risks are of a psychological trauma. Now, as lawyers who represent or deal with torture victims, you find that cumulatively you keep imbibing and assimilating that trauma, and it can really get you crazy. Lawyers in this area get burnouts. They get mental health, which they don't think is meant, they don't know. They think they are suffering from fever, they don't know. The doctors find there's no problem. Things like fatigue, all of these are risks that they attend on a daily basis to lawyers who are really on the front line. They have also a small pass from which to draw. In Uganda, some of the lawyers on the front in our area who are in institutional based, even those who are institutional based, the most donor monies were drawn away from this economy, Uganda. And when I was in Nairobi, I also found even in Nairobi, it has shrunk. But that is even more problematic for lone wolves, for individual lawyers and human rights who can't even draw a budget take somewhere. You find that they are cash trapped, and the only fuel they are running on is passion or anger, which is not a sustainable way of doing things. And then social alienation. Yes, yes.
So, Aaron, just to again further help us, there was a time maybe we could have said that institutions at least gave respect to lawyers. Yeah. But if the defenders of human rights are being treated that way, what does that mean for rule of law and access to justice in the region?
Lawyers are only second to judges or at the same level in ensuring access to justice, in ensuring the defense of rights, in ensuring that there is a rule of law taking place in the country. They are its architects, they are its guardians. Lawyers add a lot of value to constitutional making, to parliamentary legislative work, and of course to access to justice of the traditional actually representing a client in court, holding a client's hand before an administrative tribunal. Wherever there is adjudication happening, you need a lawyer to get you through the forest of rules, to get you through the corridors of power, to guide you on how to access justice. For criminal defendants, that is even more paramount, with liberty and including life sometimes on the line. You need a professional, a legal professional, to help you wade through the rules of evidence, of your rights, what you need to do, and so on and so forth. And without lawyers, or with lawyers intimidated, then you can really, really suffer. Now, imagine Tundurusu was not a lawyer. Tundurusu is one of those personifications of the daily risks that lawyers face. You remember the 16 bullets that he survived earlier, the exile that he went through, and now back in the country, he cannot be allowed to do his work. And there are some fictitious cases being against him. Fellow lawyers cannot even witness his case. One of the lawyers is here who you said is listening, who survived arrest by a whisker from TZ when they had gone there to show solidarity and so on and so forth. So once you intimidate the lawyers, you are clearly handicapping rule of law, you're clearly handicapping access to justice, because there are enough problems with this frontline legal defense, legal work. But when you add fear, then you push out many. That's why, for example, in Uganda, most times when we are gathered, you find it is the same faces over, and there are few lawyers who are into this real frontline human rights work, or frontline even natural resources work. You find that the faces are not expanding. The people who are growing old, they are not being repressed at a sufficient rate, yet even the work is expanding every year. So we need lawyers in this area, even when it is risky, but with that kind of intimidation, with that kind of institutional bias against lawyers, then rule of law is at the deathbed in Uganda and in all East African countries, including increasingly now Kenya, which was the only island or oasis of budding democracy in a dictatorial region called East Africa.
Thank you very much. those wonderful insights into the daily risk of practicing law in East Africa, most especially as a human rights and environmental lawyer. Next, we shall have Dr. Sylvia Namviru, who is the CEO of the Legal Aid Service Providers Network in Uganda. He is a human rights lawyer and a civil society actor. Join me in welcoming Dr. Sylvia Nambiru.
Thank you so much, Robert. And I'm happy to be joining this important dialogue. That is me, and I'm going to switch off the camera so that I can be able to be audible. I also have a presentation. If you can allow me, I can share it. Use 5 minutes to make a presentation, and then the questions can follow. Okay, that is me, and presenting on a topic of no one stands alone, building lifeline for lawyers at risk. Aaron has really painted a very good, my brother Aaron has really painted a good picture of what our dear frontline lawyers and human rights actors are going through. And I think this discussion is timely as it is informed by the increasing civic space, which is shrinking, lawyers becoming soft targets of intolerant governments. We have seen lawyers being arbitrarily arrested and detained, persecuted, and oftentimes are intended to be punished and intimidated, especially when they're defending rights of the oppressed. We've had the case story of our own Aaron, currently the president of Uganda Law Society, and also the former Kenyan. I wanted to say that a lawyer in danger anywhere must become a concern for all lawyers everywhere. So I'm glad that East African Law Society is taking keen interest in safeguarding the lawyers and ensuring that we are all protected. The threats I've already mentioned include arbitrary arrests, abductions, unlawful detention, among others. And therefore, it is very important to institutionalize an emergency aid and legal defense fund for lawyers at risk because of the proliferated attacks. I will not mention them again. You can see here, I list a number of them from Uganda. And this is becoming a phenomenon. For example, those are news reports where a president of Uganda Law Society is facing an international arrest warrant. Those ironies are there being spoken about prominently. His pride. So we would like to benchmark some of the experiences of standing together with lawyers using the LastNet experience. And I must also note, and Aaron has alluded to it, that even institutions that have tried to stand up have become a soft target. Right now, as we speak, some of the organizations like us who are learning legal rapid response were put in quotes to be doing subversive activities. The funding has reduced, and some of those programs that we used to do are no longer operational because of the challenges we faced with withdrawal of resources. So that legal rapid response project was funded previously by DGF and USAID, but it's no longer in, where would immediately get lawyers and coordinate them from our network, and then they are able to attend to the human rights defenders, lawyers that are at risk, among others. This program began in 2016, went through the 2021 general elections, the amendment of Article 26 of the Constitution on the compulsory land acquisition, the amendment of Article 102B on removal of presidential age limit, as well as the anti-corruption march to Parliament. So we tested that, and then the lawyers would be supporting human rights defenders, and at least would ensure that their pre-trial rights are protected. So that is, you can see one of the lawyers was even writing a bicycle, COVID especially, and then the team that was dispatched during the elections. So the strategy is to institutionalize emergency aid and legal defense funds, for example, in East Africa, would include streamline and operationalizing an emergency aid and legal defense fund through strengthening existing emergency aid and defense fund, and having proper guidelines, scope, and coordination points. It is very important to fundraise and have resources for emergency legal aid and legal defense funds that can be supported through the membership subscription or any other ways. But that fund has to be there for purposes of sustainability. Collaboration with National Bar Association would be established to ensure that we are able to coordinate. Then also we have an issue of mental health and trauma, especially for impacted lawyers. Aaron has brought it so well. Oftentimes we, the human rights defenders, and he spoke exactly when I was going through that, where you are going through fatigue, you go and check the body, the doctors gives you no results, you feel you are sick. Many issues that come up, and you listen to a lot of stories which are horrible, and that works against. So many human rights lawyers that are working risky legal representation, many human rights defenders go through this day in, day out. So the mental health as a state of well-being, where individuals can realize their potential, is very important, so that we live stress-free life as advocates and work productively. We need to be psychologically sound and feel able to feel and act, as well as our ability to interact with others. So therefore, mental health for lawyers is concerned. There's too high demanding work, unfulfilled expectations from clients and other stakeholders. Helen has mentioned the financial pressures. Sometimes you are even in courts, you are in prisons, but you don't know even what to do for your family, school fees, anxiety, and this all compounds on the continuity years. So it should be prioritized because it's now an issue and we can no longer run away from it. As you can see, that is National Monitor. Mental health challenges affecting young lawyers. Yeah, so we need to put it as a priority and mainstream it in the work we do. So, and the strategies can include designing and implementing wellness programs for lawyers, putting in place wellness policies, facilitating regional lawyers' wellness retreats, providing lawyers access to wellness facilities. And also lawyers don't go for leave. Most of the time they'll be called upon. If my brother Aaron can tell you what he goes through, even immediately he left the prisons, he was already on media. He was always talking. There was no time for him to break and rejuvenate and recharge. Why? Because there is scarcity of frontline actors. Coordinating wellness training for lawyers, resources are allowing. East African Law Society and Bar Association, as a matter of priority, have to institutionalize wellness training for lawyers. They should cover topics like diet, our health living, and how to manage stress and trauma. It is also important to have safe spaces for lawyers at risk. We need international bodies to come in and ensure that lawyers at risk can have access to toll-free lines, and there should be response both to them as individuals and their families. There is need to have relocation where necessary. And so that applies this, like I've said, to the individual lawyers and families. Yeah, safeguarding their safety is very important. And if we lose them, then we have less replacements. So there is need also the role of international relocation and protection and networks. There's need to shield lawyers at risk and their families from threats such as arrest and detention. Notable lawyers, of course, have benefited. Like we see Counsel Kakwenza and among others. There's need to enhance solidarity and support lawyers at risk. The statements that we do, the petitions, the campaigns have proved an effective tool. International networks, the East African Law Society, they've issued statements, and this should be maintained. We've seen them supporting Ms. Counsel Pio, Aaron, Agatha, among others. I'm speaking to those who are well known to me. And so that solidarity is very, very important emotionally, but also to help them know they are not standing alone. Remember the topic, no one stands alone. We are all under siege. So in conclusion, I want to say that any attack on lawyers should be construed as an attack on the rule of law and justice. East Africa Law Society, we need to pay attention to the presence of emergency aid and funds, as I have already mentioned. Further, we should build strategies to strengthen international relocation and protection of embattled lawyers and advocates. I want to thank you for the opportunity, and now I welcome questions from our moderator and participants. Thank you for listening.
Thank you very much, Dr. Sylvia Nambiru. That was a wonderful presentation. You clearly noted that we have continued shrinking civic space, funding has gone down, and then the wellness of lawyers themselves is at stake. But I just wanted to ask, because you're coming from the position of someone in civil society. Civil society is always very important in as far as documentation of human rights violations is concerned. You are in a space whereby the state seems to have decided to crack down on civil society. Sometimes I ask myself, and I would like to ask you, do we still have civil society in Uganda or in the region? Because the states or our governments don't seem to be resting in as far as cracking down on civil society is concerned.
Okay. Thank you so much for that question. It is an answer in two ways. We do still have civil society in Uganda and East Africa because the organizations are still there, the individuals are still there, and they are still operating. However, there is only those individuals and organizations that have stood the test, resilient, willing to pay a price, willing to dig into their pockets, willing to use their passion to continue saying something, to continue documenting, to continue using localized resources, to be able to remain there and defend and speak for the voiceless. However, I cannot run away from the fact that there has been gagging. The laws governing NGO operations have become stringent. In Uganda in particular, the NGO Bureau was dissolved and taken into the Ministry of Internal Affairs. There is a lot of apartheid, self-censorship. In therefore, that shows that there is a total reduction or going into trenches right now. It is not as vibrant as it was, coupled with the resources. Now, if you asked me, from the point of view of my organization, we used to run the legal rapid response, as I've showed you, for all the situations that I've mentioned. Right now, we are heading into elections. Believe me or not, there's going to be increased arbitrary arrests. There are going to be abductions. There are going to be detention without trials. We need lawyers. But even when you want to do it, the resources cannot allow you. Even when you want it did, lawyers have become, I've talked about gagged themselves or done self-censorship. So very few will pull out their heads to say we are running and we are going to defend the defenseless. So it is a situation that is dire, that needs corrective efforts, corrective support to ensure no one stands alone. We don't want to stay alone standing alone. Yes.
Dr. Sylvia, you see, you've just talked about the issue of us going into elections by the end of this year. Yeah. But as civil society, how are you strategizing in as far as responding to such human rights violations in this kind of environment? Most especially with the issues of lack of funding, and the state will not relent, to use that kind of word.
Like I've already mentioned, the strategy remains as far as strong our institutions and visionary leadership. So that means we need to have coordination. We need to have to network. The national bar associations have to stand and live to the expectations, in addition to us, the civil society organizations that are involved in access to justice. So we need more volunteer spirit than resources, because the funding is not there right now. We don't have DGF, don't have USAID, don't have European Union. All the resources that we expected right now as we go into elections are not there. So we need the individuals, and that's all. We are going to depend on our networks. We are going to depend on the goodwill of our lawyers within the NGOs. We are going to depend on the goodwill of the National Bar Association to mobilize so that we can together continue the defense of the defenseless amid this lack of resources.
Thank you very much, Dr. Sylvia Nambiru, for being part of this conversation, but for that wonderful presentation. I know you had earlier on asked to leave before the session ends, but should you reconsider your decision, we shall be happy to continue having you on the
I'm going to be online. I'll be moving, but online, listening in.
I don't know if Mr. Kabata is on the call now, Gabi.
Senior Kabata, unfortunately, is not yet on the call, but we can proceed with Ms. Chogero and then probably take a round of questions. Thank you.
Thank you, Gabi. Ms. Chogero, you're welcome. To our audience, Chogero is the managing partner of ABC and Partners Advocates. She's a human rights, also public interest lawyer based in Tanzania. Tanganyika. You can correct me. This Chogero, you come from that people thought that
You're not clear. We cannot hear you
Am
clearly.
I now audible?
Yes, if you could, I don't know if you could.
Yes, I was saying that you come from a country where people around the region thought that maybe having a female president, things could change. But we are now seeing lawyers being arrested every now and then. Human rights defenders being kidnapped, arrested. But this is not just in Tanzania. It seems to be the unifying factor in East Africa. From your position, you could now get into your presentation. And the question that was asked to you was, between the law and power, do current legal protections actually work? You're welcome, Ms. Priska Chogero.
Thank you very much, Mr. Moderator. And thank you very much to the East African community, ELS team for having me here. I will switch on the video just so at least the voice can be put to the face. And then, yes, and then I'll switch it off so I can proceed with the presentation. Yes, thank you very much. So you said, even though we are having a female president in comparison to the other countries, but still the challenges are still the same. I think you have heard the experience from Uganda. Also, the presentation from the previous presenters is we are not standing very far from that. And I think I can start from the last comment, which Dr. Sylvia made, that no one stands alone. We have to stand in unity. And actually, I thought about it because it has been a practice here that when the cases of high political interest, you unite, you create a bigger team of defense lawyers, those who are going to argue that case, if it's a constitutional case, mostly if it's a public interest case, so that at least you are not singled out as one lawyer. So that has worked. And actually, when I was preparing for this presentation, I was like, okay, now, Gabriel, you have singled me out. I'm standing on my own here. But yes, so just to answer your question, does between the law and power, do current legal protections work? It's quite, it's a question which is quite wide, and we can talk about it from every angle. But when you look at it, we have very progressive constitutions in all our countries. Even though in Tanzania, we're in the verge of demanding for a new one, but still, the one which we have has the Bill of Rights, and multiple rights are enlisted there, and they're supposed to be protected, but still, there is still a violation which are ongoing. So what we have firstly, there is the promise of law and there is the practice of power. So we have the law, which is now promising us equality before it. It's promising us access to justice. It's promising us the accountability, the freedom of speech, movement. But we are seeing it in the actual practice. That's not what is happening. So we are not getting the promise as the way the law is promising. Firstly, I think most of us, we have seen yesterday, actually, if I'm going to speak on the promise of law versus the practice of power, when ELS actually issued a statement on the unlawful deportation of Mr. Martin Mavenjina. So it's just very directly like that. The law allows a person to work in a country so long as they have valid work permit and a valid resident permit. But again, the power can actually decide, like the way they have done, to actually deport a person without explanation. So these are instances which now there are areas which we really need to look at when it comes to these affairs. So again, in Tanzania, if I am to speak of the protection, we have our own, the law which now establishes our own society. It has established the society which is supposed to be very independent, which has the mandate, among others, to protect its members and to protect the rule of law. And again, the Constitution itself is existing. We have multiple reforms, which can also be argued can be protective or also restrictive, depending on who is viewing. On the side of the lawyers, we see most of the reforms or the enactments are becoming quite restrictive. And then with that, we're also seeing threats which are being faced by the lawyers in Tanzania. Mostly, they are being attributed to state interference. Because I think it's the same instance, it's more or less similar from what Mr. Aaron was presenting. But there are issues, for instance, a threat to be suspended from practicing law. It's quite severe because, you know, if you're a private practitioner, that's your bread and butter. That's where you derive your livelihood. So if you are either suspended or you are being removed from the role of advocate, that's quite severe threat. So if it's used against an advocate, it really places the trauma. And we have seen several advocates who are working in the space of public interest litigation, who are working in the space of constitutional law. They have been subjected to disciplinary proceedings. And some, for instance, one, it just ended in the middle of it. Now, it also shows again, it's the law versus the power and the practice. So the proceedings can be instituted and the proceeding can be terminated depending on how it's being viewed by the state or the government, I would say. So some have also faced multiple attacks. Some have been physical, some have been verbal. But I think the most notable, which it also echoed around the East Africa region, I think we can recall the attempt on the former president of TLS, who is Tundu Lissu, on his life when he was gunned by he was shot multiple times, which really threatened his life. By that time, he was a sitting president. So the incidents cannot be really disassociated. You look at them and you look at the work of a person, look at the work which a person is doing, you actually link them. Equally, the threat on the society itself, I would say. Previously, there were a lot of threats on the society to either abolish it or even some attempt to weaken it. But still, you could see, because we are the lawyers are the ones who are speaking on behalf of the civilians. So it becomes quite, you look at it when there is a threat on the society, you look at it, it's actually the threat on the independence of on the freedom of expression, on the independence of the judiciary, because we are the officers of the court and the like. So similarly, limitation on freedom of expression, because there's a lot of censorship, you really have to censor yourself. What are you going to say? Like they have given an example here, like, you know, we prepare public interest litigation as a group, maybe under the support of a civil society. So there's quite a lot of backing of colleagues, you know, like I'm here with Legal and Human Rights Center, the HRDC, you know, you have backup. But then when you are standing on your own, there is a censorship which comes to you automatically, because still the space is not that safe. So the effectiveness of the systems, do we have systems which are effective? Yeah, so the formal system are there, because I think that's cuts across all the East Africa region. We have quite elaborate legal framework, which it cuts across. So you can, if you are looking for protection within the legal system, the protection will be existing. But then again, does that apply when it comes to actual life, day-to-day life? That is being found to be lacking. So still there is interference of the executive. We could say political interference. There is a question of judicial independence, because last year East Africa Law Society actually launched an index for the rule of law in the region, which was highlighting the years 2023 and the first half of 2024. But looking across the region, the observation was mainly the legal framework exists, yes, but then if you're looking at independence of the judiciary, that's a question, because the cases are being filed, but again, the court is a bit skeptical. The safety of the lawyers are still lacking. Lawyers are not free. They can't say, you can't stand boldly and challenge issues on your own and be assured of your safety. So your freedom of expression is guaranteed, but freedom of expression, that's left to be desired. So those are the things. But then again, I can look at it in the same line of questions when it comes to the general public. We have laws which have been enacted, which are infringing other professions as well, not necessarily the lawyers. For instance, in Tanzania, when you look at Media Services Act, this law actually, it has been challenged since its enactment because of not meeting acceptable standards for the promotion of freedom of expression. And also it's viewed as oppressing. So it has been challenged domestically, it has been challenged in the EACJ. Domestically, the case failed. At the EACJ, we had a very good decision, which actually held the government accountable that it has infringed the treaty for the establishment of the community, but still the enforcement or implementation is still lacking. So we have those incidences. But from that, I could say the lesson which we are learning, irrespective of all the hardship or the need for the pushback, is that we have the law, but the law cannot really protect, but the pressure which it can come either from the civil society, in our case, or united advocates can actually work and enforce the protection. Because even in those instances where we got a little bit of positive feedback, I could say, is because there is a pressure. And in Tanzania, I think also I could recall the question which moderator asked Dr. Sylvia. The civil society is actually backing the public interest litigation movement in Tanzania, because now moving as an individual, very few are moving on their own, but the civil society has been standing to make sure if there is an enactment which is violating the constitution, it's actually challenged in the court. So with that, we have also an issue of legal protection, but there's also an issue of selective enforcement. So you could find, if we are talking about public interest litigation, cases can be litigated, a decision can come out quite positive, but then is the state really willing to enforce that, to ensure the actual protection of actual protection is existing? So that's also an area which we could discuss further. We have some few cases which we have won, but again, the government is being given time to execute, to make the amendment, which leaves people still exposed. So when can we say the law protects and when can we say it does not? We can say it protects if we have institutions which are actually independent and resourced. Because if you have a judiciary which is not well-resourced, or which say there are directives from the executive on how they conduct their affairs, or the judges are not very bold, so to say, now we can't really say the law is actually protecting. Also, the civil society has to be active. Also they have to be protected, because even though I've commented earlier that the area in Tanzania is being backed by civil society by large, but still they are not really protected. They're also facing the challenges on their own. There is a lot of power on the registrar of societies, which it can also infringe on the civil society to execute their works. And also, as I highlighted in the research which came out, the judiciary in Tanzania or even in East Africa itself is being seen as not quite independent. Also, there's an issue of public trust. Do we trust the system to protect us? Like, does the public really trust the judiciary system? Does the public trust the police? Does the public, because now once you're arrested, everybody, in Tanzania, we know you got police free, but you just can't come out as you went. So once a person is arrested, really all resources have to be launched, because for sure the chances of you finding that person are limited the more you delay to look for that person. So I can, just to conclude, I would like to echo the previous presenters that we cannot work alone. What can we do as lawyers? We can still push for public interest litigation. We can litigate strategically. We have some few wins. They are not as much as we want, but still there is a room there which we can influence change. That will be through challenging the laws which are either vague or which are oppressive. We can still defend the civic space and the judicial independence. That's also another area which we can interfere. That can be either through our own publication, through support, through litigation again. But most importantly is to engage in regional solidarity. I think this one is quite important. We have seen some positive outcome, for instance, in Tanzania. If you're working together with other lawyers in different jurisdictions, in preparing for cases, in seeking assistance in research, in seeking something like that, is something which can work in our favor. Yes, so just to conclude, I can say between law and power in our East African context, we can say we have seen a lot of, most of the time, the power has been winning. But yeah, it's not a reason for us to give up. Thank you very much.
Robert, we've lost you. Your sound is unclear.
Yeah, I was saying that thank you very much, Ms. Priska Chogero, for that wonderful presentation. And from your presentation, we note that our constitutional documents seem to be progressive. And then we also note that there are continued attacks on human rights defenders. And then there's a lot of political interference. and then there's lack of public trust. But I would like to ask you, Priska, when you look at these three arms of government, the executive, the judiciary, and the legislature, when you look at the way they relate with each other, do you think there is a connivance for them to create a disabling environment for human rights defenders in the region? And how do we navigate such situations?
Thank you. Well, I'll answer your question by first recall there was a comment which was made, I think, a year or two ago by our speaker, who said we have the three arms of the government, but it doesn't mean they are equal. One is stronger okay, the comment was made in Swahili. I'm trying to do direct translation. So she was actually commenting in a sense that the executive is above the remaining two. That was the comment. So if you say, if we look at the three arms of the government, whether they are conniving sort of to limit the rights of the human rights defender, I would say that was the perception where we see, for instance, previously, you could develop a very wonderful case and submit it before the court, but surprisingly, it's just thrown out on very flimsy grounds, or it can be on preliminary objections, which truly, you look at it, they are not holding water. So we can't say there is evidence that they are actually working, but those environments were really discouraging the lawyers. But I can say we received a judgment of the Court of Appeal that was a month ago on Onesmo Olengurumwa against the Attorney General, which actually the Court of Appeal overturned the decision of the High Court, upholding that, they actually ruled that the amendments to the Basic Rights and Duties Enforcement Act were unconstitutional. Because when you speak of public interest litigation, people should actually access, because the amendment was limiting who can access the court for public interest litigation. You have to show that you are personally affected. So for me, that decision, really reading through it, maybe every one of you can also find a copy and read. It was actually, for me personally as a person, I felt like it's a turning point. So maybe some might differ with me, but I felt there's a turning point which I think we are going to experience or see moving forward on the work of the judiciary to ensure protection of the rule of law. So I'm optimistic. That's what I could say. Thank you.
Thank you very much, Ms. Priska Chogero, for that wonderful discussion. Mr. Kabata seems unable to join us, but we shall have Mr. Gabriel Achaye, a Senior Program Officer, Public Interest Litigation and Communication at the East African Law Society, join us. You're welcome, Mr. Gabriel Achaye.
Thank you so much, Robert, and thank you, my esteemed colleagues, for this very wonderful discussion that we are having this afternoon. Not only is it timely, but it is really necessary for the profession to have a conversation of this nature at such a time. I would like to give my two cents in this ongoing discussion. And one aspect that I really would like to tackle is the power of coordinated legal advocacy and solidarity across national borders. And I love what Dr. Sylvia shared in her remarks about the importance of having a rapid response that is functional and is there to rescue advocates. I have had the benefit of serving under the rapid response in Uganda, and I have seen just how effective and how necessary it is to liberate our members who are always on the front line advocating for the rights of people. And it's been stated already, it is very clear now that the profession is under siege. And ladies and gentlemen, it's not by accident, it's not by isolation, but it is by design, because we have witnessed increasingly disturbing escalations of lawyers being surveilled, like my senior Aaron had mentioned in his presentation. And we've seen now the rule of law is being branded as an obstacle to power. We are seeing more attacks, like my senior Aaron has said, on lawyers, and basic attacks on foundations of constitutionalism, such as the social contract that the citizens have with the state, on the rights of the citizen and on every idea of justice. But I'm happy that today we are having this conversation because, one, we are not silent, we are not scattered, and definitely we are not alone. Today, I speak from the standpoint of coming from a regional bar that covers all the sister bars in the region. And at the East Africa Law Society, we know that injustice does not respect borders. We have seen it, we have lived it. So neither can our resistance also respect borders. And that is why we are here. We've seen incidences of lawyers being assaulted and persecuted in Uganda, Burundi, Tanzania, and even Kenya for doing their jobs, like my senior Aaron shared. But as ELS, we respond at a regional level and we speak out collectively and with solidarity, because a threat to one lawyer is a threat to us all. We have been at the front line of defending lawyers. I can give you a very recent example when our seniors were illegally detained at the airport and deported back to Kenya. We issued statements, and we did not just stop at issuing statements. We coordinated joint declaration from our national bar leaders. We engaged a network of diplomatic and media partners, and we even coordinated directly with grassroots responders on ground to ensure that our members were released. And indeed, we saw that our members were safely taken back to their country of origin, not because of diplomacy alone, but because of pressure, visibility, and having a collective voice. So let's be clear. This cross-border advocacy is not charity, it's strategy, it is survival, it is power. In moments of crisis, I would like to say that speed is everything. Our oppressors often move so fast, so we must move. And as such, we have developed real-time legal coalitions, rapid response systems, and I'm happy that Dr. Sylvia has talked about the importance of having a rapid response system that is dedicated to work within hours and not weeks. Because when a lawyer is threatened or arrested, we are often sure that at least we'll have legal observers on ground, we'll initiate emergency support, and we'll issue real-time alerts to ensure that our members are ably updated on that. And of course, in coordination with the international bar associations and human rights defenders. Now, these coalitions are underpinned by protocols, pre-trained legal teams, and emergency funds, because preparedness is always our shield. We have several examples that we can give that can show the importance of having a rapid response mechanism. But again, the third one is controlling the public narrative. I think as human rights defenders, we must learn to control the public narrative before it controls us. For example, in every attack on a lawyer, there are always two trials, and we all know it. There's the trial in the courtroom, and there's the trial of public opinion. Oftentimes, we've seen that oppressive regimes are smart because they do not just jail lawyers, they discredit them. They paint them as agents of chaos, foreign puppets, enemies of the people. And that is why reclaiming the narrative is of fundamental importance because public opinion is a battlefield. And when you are silent, it is surrender. So we urge and we invest in strategic storytelling. I would like us going forward as activists and advocates to humanize the lawyers under siege. We need to show the public that defending the law is defending them. And we can make use of short form videos, press kits, regional media alliances, and digital campaigns to flood the space with facts, faces, and principles. I like what my senior Aaron is doing with the Free BCJ campaign. And this is an example of strategic storytelling in the face of advocacy. The other thing that I would like to maybe call for members to have is the need for more of these stories. We need to be loud. We need to be intentional and relentless in framing lawyers as defenders of society and not enemies of order, as authoritarian regimes often want to look at us as. So in closing, I would like to state that in every era of oppression, there are those who retreat and those who rise. Let us choose to be the ones who rise. As ELS, we look forward to building a regional safety net for lawyers at risk, a coordinated legal front that defends rule of law across borders, and a bold and unapologetic public voice that will not let authoritarianism hide in silence. But we cannot do it alone, and that is why we are having this conversation here. We call upon you, brothers and sisters in the legal profession across the region and beyond, to link arms, to share tools, and to stand as one. Because when lawyers unite across borders, across languages, across systems, we become something more powerful than an association. We become a fortress of justice, and let the message ring loud and clear. We will not be silenced, neither shall we be scattered. And we are louder together. Yes, Robert, sorry?
Please conclude.
Yes, I was concluding. Thank you. I think my internet cut it.
Thank you very much, Mr. Gabriel Achaye. You make a very wonderful discussion there. But just one question for you. You see, the bar and the judiciary have of late been at loggerheads. Should we negotiate or should we push back?
But I love the question that you have asked me. Should we negotiate or should we push back? I would like to state that when lawyers are silent, when justice is crippled, when bar associations are silenced, the silence becomes complicit. As it's been not stated across the platforms, we are in a very serious struggle as we speak. And bar associations should not be neutral in terms of democratic erosion. We are not clerks of convenience or commentators of repression. We are constitutional actors, institutional guardians, the conscience of the legal system. That is who we are. And I would like to state, Robert, that bar associations owe their members, and it's the first duty of any bar association to protect its members, especially when they're under attack for upholding their oath. In East Africa, we have seen it. It's not theoretical, it is lived. We've seen lawyers jailed in Uganda, advocates harassed elsewhere, and then disbarment threats, like Priska had mentioned, are ongoing. So, bar associations must be first responders and the last line of defense. What does this mean, Robert? It means bar associations must publicly condemn state overreach, deploying legal systems to defend affected lawyers, issuing emergency alerts to regional and global partners, and when necessary, standing in the courtroom besides the accused to say, you will not face this alone. And here we have seen it firsthand at how bar associations, when united and strategic, can turn isolation into solidarity and vulnerability into strength. So I would like, thank you.
Thank you very much, Gabriel Achaye, and the other panelists who have made a great contribution to this conversation. But Gabriel, before we get into the Q&A, we have one of our very senior members of the bar in the audience. And I would like to go through you to invite him to say something about contempt procedures being used to punish lawyers or human rights defenders. If Mr. Philip Karugaba could join the conversation here. I know he has been documenting cases where lawyers have been taken to prison as a result of contempt procedures. Mr. Philip Karugaba, please, if you could, please join.
Min, can you kindly unmute Mr. Karugaba? Robert, just a moment. Let's handle that while Senior gets on.
Yeah.
So in a minute, okay. I think Senior Karugaba is on now. Senior, you can unmute. Thank you.
Thank you very much, Gabi. And you're welcome, Mr. Philip Karugaba.
Thank you, Mr. Okot. Can you hear me?
Yes.
Very good. Thank you, Mr. Chaye. Good afternoon, everybody. Thank you for the good work that you're doing. Thank you for the interest in these matters. With respect to contempt of court, I've been running a series of tweets on reviewing the cases of contempt of court in Uganda that we have seen lately, focusing on Ivan Sebaduka, who was sentenced to 36 months by the Supreme Court, followed by the rule of law champion, Malema Mabidizi Chwanuka, who got 18 months, and then followed by Isaac Chimazese Makade, who has 24 months. Now, the first two served their sentences and completed them. Mr. Semakade has been out of town since sentence was passed. But what I have observed on reading the authorities is that the procedure adopted in all the cases, including the Supreme Court, violates the basic principle that you cannot be a judge in your own cause. That basic principle has been expounded on in Luchamuzi versus Attorney General. In that case, it was a challenge against the IGG prosecuting Luchamuzi after being involved in the investigations against him. There is another case of State versus Mamabolo, a South African case, which states clearly that that is a violation of a right to a fair trial. And it says the only exception is if the contempt is contemporaneous. If, let's say, you started a fracas in the court and the judge needs to restrain you to regain control of his courtroom, he then can act against you directly. But in all other cases, the recommendation was that you refer it to the ordinary prosecution services. There is also a judgment of Isabire Kawesa, Justice Isabire Kawesa, in a case called Okurut, where he nullified a conviction by a trial magistrate who again had convicted for contempt a litigant who had fastened his hands on the throat of the counterparty in open court. And Isabire Kawesa said that that's not right. You should have referred it to someone else to litigate. Now, when you apply it to our cases and you see that Justice Musa Sekana is the offended judge and he's being offended out of court, he is the offended judge. And then he's the one sitting to determine the gravity of the offense caused to him. You know, it's something I think we should have opened our eyes to long ago. When Ivan Sebaduka was detained in Ginger Road Police Station for 1 week, pending his trial for contempt, he isn't an advocate. We looked the other way. And what he had said to the Supreme Court judges was quite outrageous. No one bothered. Then when it came to Malema Birizi, his issue was against Odochi, but yes, he was tried by Sekana. That's so there's a slight difference there. Okay. But again, he was not an advocate, and maybe again that's the reason why we looked the other way. Okay. Now finally it has happened in our own home, our own president, and it's a bit too late. The presidents are there, they have been set. To overturn them is going to take some doing. Thank you. I hope I have contributed to this debate on that issue. My X account has the cases, the links to the judgments. Thank you. Thank you.
Yes. Thank you very much, Mr. Philip Karugawa. Maybe just one more question. Are we seeing the judiciary trying to protect itself?
Yes, that is true. That is, it would appear to be the case that the judiciary is trying to protect itself, but the underlying issue is that this power for the judiciary to protect itself in that manner is now questionable following advancements in the common law countries from which we get this. I think in England, they lost that power in 1981. And the general call, when you read Mwenda and Onyango Boa against Attorney General, Kakuru, Justice Kakuru, whom we honored this morning at LDC, he called for public officials, for justice officials, public officials in that case, to have a thick skin. He said they will necessarily be subject to scrutiny and criticism by the public by reason of the offices they hold. And they should have a thick skin and expect criticism. And another judge said that the better defense for a judge, instead of resorting to contempt, is a higher standard of conduct in public office. It's the integrity that will protect them from things like this, rather than resort to primitive tools like contempt. Thank you.
Thank you very much, Mr. Philip Karugawa, for that insightful discussion on contempt procedures and how that affects human rights defenders. Mr. Gabriel Achaye, I would like us now to get into the Q&A session.
Well, that's perfect. And in Q&A, we call upon members to raise their hands if you wish to ask a question. Raise your hands and let us know. And in the alternative, if you want to drop a comment, please drop it in the Q&A. I'm glad to announce, Robert, that finally Mr. Kabata has joined us, and it would be really good to hear from him as well.
Thank you, Gabi, and you're welcome, Mr. Kabata. Mr. Kabata is the Vice President of the Law Society of Kenya. Mr. Kabata is here. Mr. Kabata.
Okay. Robert, I propose probably we proceed with some of the questions.
In the comment section, someone says, that is Sinkian Tobiko, that in Kenya, a judicial officer was killed while in a court session, Honorable Monica Kivuti last year. They add that another was stabbed in court in 2017 or 2018. And then Scholastica Julu says that in Tanzania, advocates, especially those defending the so-called opposition parties or those defending disadvantaged communities from investors or those criticizing the ruling party are in trouble. Most of the harassment is championed by the police. It is very normal for the police to arrest advocates while doing their job of representing their clients. For me, the judiciary, particularly in Tanzania, is not bold enough because they are also not free to do their job. The appointment of judges is a big challenge. Scholastica adds that what I noted is that most East African states have ratified key international and regional instruments like the African Charter on Human and People's Rights, yet implementation is not there. And then someone again says, advocates take oath of office. To what extent do we uphold that oath, whether serving in private practice, legislature, or judiciary? Then there's someone who says, there are measures in place to ensure safeguarding of rule of law, but in a country like Kenya, it is fellow land friends that are on the forefront. We need to put in place measures to strip them of their membership in the association and punish them even after they leave those positions of power that they are using to oppress citizens. To defend lawyers is to defend justice. That is from Stephen Modi. To safeguard the rule of law is to safeguard democracy, peace, and development. The threats are real, but so is our collective strength. Across East Africa, brave lawyers continue to rise despite fear, despite anger, danger, because they believe in a future where justice is not just an ideal, but a lived reality. Let us stand with them. Let us be their voice when theirs is silenced. Let us defend the defenders, because in doing so, we defend ourselves, our values, and shared humanity. I think you've heard the comments from our audience. To start with, Mr. Aaron Kiza, any responses to some of those comments?
Robert, I think Mr. Kiza has dropped off call as he was on the road.
Ms. Chogero, if you could respond to some of those comments.
Thank you, moderator, and thank you for the engagement which you have received from the audience. Yeah, I could say the risk is quite great, and the protection also is also lacking. And we are having the lawyers who are also need to be protected by the law itself, which we are upholding. And again, the society which we are serving. So the balancing is quite striking. But then again, I think I could echo the previous comments which you have made. We have to push forward. We have to push forward irrespective of the challenges which are being faced, because the changes can only be obtained if we have the law which is actually protecting our rights. So still, we need to push forward. That's all I can comment for now. Thank you.
Okay.
Robert, maybe just to chime in on the comment that was made by Mr. Modi, I would like an answer to say that that's a deeply moving reflection, Mr. Modi. Indeed, like you've rightly stated, to defend lawyers is to defend the soul of justice. In East Africa, lawyers are rising every day, not because it's safe, but because it's right. And that courage demands more than admiration, it demands collective action. When we protect lawyers, we protect ourselves, we protect democracy, we protect the future. And I'd like to indeed agree with you and agree with us all. Let us stand with each other. Let's stand for those who are in the middle of a crisis and those who are under persecution. And let us act with purpose, because that is how justice becomes more than an ideal. That's when justice becomes a reality. Thank you.
Thank you very much, Gabi. I don't know if Mr. Kabata is ready. If Mr. Kabata is not ready, I would now like to, first of all, say that today's discussion has highlighted the critical importance of supporting lawyers who face risks and challenges in their work. We've had powerful insights from our panelists on the need for solidarity, protection, and support networks to ensure that lawyers can continue to defend justice and uphold the rule of law. Therefore, as we close this webinar, I urge each of us to take away key takeaways and commit to action. Let's work together to create a safer and more supportive environment for lawyers in the region. Let's amplify our voices to promote justice, human rights, and the rule of law. I would also like to extend my gratitude to our esteemed panelists for sharing their expertise and experiences. Thank you to our audience for your active participation and engagement. Together, we can make a difference. Thank you, Gabriel, and the entire East Africa Law Society leadership for ensuring that we continue having such conversations despite the fickle environment we are working in. Let's stay connected, members, continue the conversation, and work towards a future where lawyers can practice their profession without fear or intimidation. Thank you. Back to you, Gabi.
Wow, thank you so much, Robert. It's indeed been a very wonderful discussion with our esteemed panelists. Thank you so much, Mr. Aaron Kiza. Thank you so much, Mr. Maura Kabata. Thank you so much, Dr. Sylvia Namobiru. Thank you so much, Madam Priska Chogero. Senior Philip Karugaba, thank you for jumping into this discussion. And to you, our esteemed moderator, Mr. Robert Okot, it's really been an excellent discussion. And I think let's keep this discussion going ahead. Let's keep it going forward. I believe that together we can form a safe society for every member to practice without any sort of persecution, without fear or favor. So let's keep this fire burning. Let's connect more. Let's keep this conversation going on Twitter. Next week, we'll be having another set of very interesting sessions to discuss, and this time we'll be discussing mining law, and we're looking at mining for a just and sustainable future in East Africa. You do not want to miss that conversation, and we want to look at legal leadership in a multi-generational dispensation. So we thank you so much for joining us. We look forward to hosting you again next week for another session. And also, we would like to take this opportunity to invite you for our in-house council convention that is happening in the month of August on the 28th and 29th of August 2025 in Kigali, Rwanda at the Serena Hotel. So you want to register for that session, visit our website at www.elosociety.org or reach out to us at info@elosociety.org. get more information about that session. We look forward to hosting you in Kigali, and we look forward to seeing you in Addis Ababa, Ethiopia in November for our annual law conference. I would like to thank you so much. You stay blessed until we meet again. Goodbye.
Thank you, Gabriel.